Good afternoon, everyone. My name is Tim Fortier. I'm the Communications Coordinator with New Hampshire Municipal Association. Thank you for joining us for this 2021 webinar series, specifically an introduction to the Housing Appeals Board, or a new look, or a look at the new Housing Appeals Board. We are joined today by our Legal Services Counsel, Stephen C. Buckley.
Good afternoon, everyone. Good afternoon, Tim.
Yes, good afternoon. Oh, and there you are, Steve. That's our presenter today. Steve, with that, I will turn the program over to you.
Tim, do you think we should wait a few minutes to make sure everyone is in? I see we've got 41 participants joining us. Maybe that's a full house, and that's great. We'll go ahead and get started. So yes, I'm your Legal Services Counsel, and thank you, Tim, for having me here today for this presentation on the Housing Appeals Board. So let me just give you a few bits of housekeeping information. We are using Zoom webinar for this presentation today, so you can't unmute your microphone, even though I would love to hear from you live and in color. It's set up so that you have to use the Q&A system. So I will keep my eye for open questions and try to answer them as we go along, but I may end up saving a bunch of them towards the end and try to answer them within the time that we've allotted today. And if we go over, that's okay. We can go past 1 o'clock. Tim won't get angry at us. So again, it's a Zoom webinar, and you can ask your questions in the Q&A. So just look for the Zoom toolbar, open up the Q&A, and I'll keep my eyeball open for questions that you have. So my agenda for you today is to go over what is the Housing Appeals Board and how they address appeals from local land use board decisions involving housing and housing development. We're going to review the jurisdiction and procedures of the Housing Appeals Board by going through key elements of the governing statute, RSA Chapter 679. And I'm sure you all have it because the current version of the Zoning and Planning Handbook, the one with the white cover, has RSA Chapter 679 in that book. And that is the currently applicable things that govern the statutory governing provisions of the Housing Appeals Board. And at the current time, just so you know, the board has put into place through the administrative rules process their own administrative rules for governing their procedures, and they're available. And there's a slide on this that they're available to you for access to more detailed information on the management of and handling of appeals before the Housing Appeals Board. And then we're also going to be taking a little time discussing some recent decisions, two decisions I think are most important to municipalities by the Housing Appeals Board involving the Town of Francestown and the Town of Pembroke. And again, we're focusing in terms of this presentation primarily on the governing statutes, RSA 679:1 to :29. So let's start. And to start at the beginning, I think, with any appeals or appellate tribunal is the composition of the Housing Appeals Board. By statute, it is to be composed of 3 people, learned and experienced in questions of land use law or housing and development, or both. 1 member has to be a practicing attorney licensed in the state of New Hampshire. 1 member has to be a professional engineer or land surveyor. And the full board, the members of the board shall be full-time employees, and they're not allowed to engage in other employment or appointments during their term of office that conflicts with their duties as a member of the board. So that's the standard that governs the appointment and potential outside conflicting other activities beyond their work for the Housing Appeals Board. Excuse me. And the Housing Appeals Board, I've been to their offices a couple of times now, is in Johnson Hall, which I'm pretty sure is the same building at the Governor Hugh Gallen State Office Park South on Pleasant Street in Concord. I'm pretty sure that's the same building that houses the Board of Tax and Land Appeals. And that's appropriate because the design of the Housing Appeals Board, as I understand it, is mainly to be very similar to the Board of Tax and Land Appeals. So the board members are appointed by the Supreme Court, and then they're commissioned by the governor for a term of 5 years. So there's a combined relationship with the Supreme Court being the ones who vet the persons being proposed for membership on the Housing Appeals Board. And then those members get commissioned by the governor. And the Supreme Court is required to designate one of the members as chair to serve in that capacity for the duration of his or her term. The current members of the board are Gregory Michael, who is the chair of the Housing Appeals Board, Elizabeth Fisher, who is a member who, as I understand it, her background is in real estate, and Edward L. Rogers, whose background is in engineering or surveying. A couple of questions just came in. Does a ZBA appeal have to be related to housing specifically, not a detached garage in wetlands or a business? So Nancy, let me get to your question in a bit. I think I'll be able to answer that when we get down to the section of the presentation that deals with the jurisdiction of the board. So just going to go back to the board appointment. So this is a currently constituted Housing Appeals Board, Attorney Michael, Elizabeth Fisher, and Edward L. Rogers. So what is the authority and jurisdiction of the Housing Appeals Board? And this may more directly answer Nancy's question. So the board has authority to address parties who are aggrieved by a final decision of any municipal board, committee, or commissions regarding questions of housing and housing development. So to get to Nancy's question, does a ZBA appeal have to be related to housing specifically? Housing has to be part of the decision-making that relates to what the ZBA did. So if the ZBA was just deciding whether or not to approve the attached garage, then that wouldn't be within the jurisdiction of the Housing Appeals Board. However, if the attached garage is going to have a frog, as I understand it, family room over garage frog, and it therefore could be a dwelling unit, then it would involve housing, and it could be within the jurisdiction of the Housing Appeals Board to deal with that particular issue. And a couple more questions Nancy has, we'll get to those in a second. So just to complete the concept of the authority and jurisdiction. So very specifically, the board can hear and affirm, reverse or modify planning board decisions on subdivisions or site plans, Board of Adjustment decisions within the full panoply of the ZBA's authority. ZBAs have authority over administrative appeals, special exceptions, and variances. And sometimes innovative land use control, although it may come under the planning board decision making under innovative land use controls. And that's why specifically decisions under innovative land use controls, which are normally administered by planning boards, but sometimes can be administered by ZBAs and select boards. Board can also address growth management controls, interim growth management. It includes decisions of historic district commissions, heritage commissions, and conservation commissions. And this is the kicker, and I put it in here in red. Other municipal permits and fees applicable to housing and housing developments. And so where I will touch on that specifically is in the Pembroke case, the decision was by a select board that was a party was aggrieved about, dealing with whether or not the select board would approve the layout of a class 5 road, a class 5 road over an existing class 6 road. And that was something the board had jurisdiction over because it directly connected to a proposed housing development. And then, and this again, probably to some degree addresses Nancy's questions. The question by Nancy Hoyer, matters subject to the board's authority may include mixed use combination of residential and non-residential uses. So you could have a combination of housing and commercial, or housing and non-occupied parts of a building that aren't used for residential purposes. So that's the authority of the Housing Appeals Board. Very specifically, the statute does delegate to the Housing Appeals Board the authority to grant remedies which are available to those who are aggrieved under the workforce housing statute. So under RSA 674:61, specifically the workforce housing statute, the Housing Appeals Board can decide whether or not if there's an appeal of a land use board decision involving a workforce housing, whether the land use board, whether the municipality's land use ordinances were providing realistic and a reasonable opportunity for workforce housing, whether the land use board decision imposed conditions that rendered the workforce housing economically unviable, and whether the land use board decision was unreasonable or unlawful. So I would characterize this as a supplemental way of understanding what the board can do in this particular unique situation, imposing or addressing a community's compliance with the workforce housing statute. Just checking my answers. And I think you see Tim is marking them off for me. Thank you, Tim. That's the jurisdiction. That's the particular remedies under workforce housing. So who has standing? Who could appeal to the Housing Appeals Board? Well, they, in the first instance, have to be brought by a person who's aggrieved or injured who can demonstrate standing. So that's someone who applied for a permit from the planning board, subdivision or site plan, or a ZBA relief, which are the easiest ones to understand. And there was a housing element or a complete housing project that rested or required that particular permit, and the person was denied. But it also allows those who are claimed to be aggrieved or injured who can demonstrate standing. So someone who resides in a community who is not an abutter and can't show that they are directly affected by, let's say, a large housing project, and they live on the other side of town, but they really don't want that housing project in town, they don't have standing because they can't show that they're directly affected. So while there might be those in your community who are really concerned about a project, if they don't have a direct impact on their property, they won't have standing. So, but abutters and those who are directly affected by the land use decision would have standing. The municipality is automatically a party to the action. That's just the nature of any land use board decision. That's no different from the fact if you appealed a decision by a land use board to the Superior Court, the decider of either granting or denying the permit is a necessary party to the proceedings, and that's the municipality. If the applicant is not the party initiating the action, the applicant is automatically made an intervener. So if someone is aggrieved by either a grant or denial of a permit involving housing, and they're in a abutter, and they appeal to the Housing Appeals Board, theoretically they could, the applicant for the permit is automatically made an intervener. And again, the board shall grant intervener status to abutters to anyone else who can demonstrate legal standing. That is, they are directly affected by the land use permit in issue or in debate before the Housing Appeals Board. So what can the Housing Appeals Board do? Well, the board has almost the exact same, I would actually say, better but put it this way, they have the exact same authority. The board has the exact same authority as the Superior Court. So all remedies that would be available to an aggrieved party appealing to Superior Court in similar cases, and that would be under RSA Chapter 677, which is the statute that governs appeals of land use board decisions, would be included in the available remedies the Housing Appeals Board can award to an aggrieved party who, again, in most instances, we're probably talking about someone who's trying to build a housing project and got denied, or trying to build housing. That includes something called the builder's remedy, which you might be familiar with. It was something I think it would be fair to say was initiated in the Chester case some years ago, where in that particular case, the Supreme Court decided that in Britain versus Chester, that the applicant had done enough proceedings before land use boards, and they didn't have to go back to the town for further permissions, and they were just granted permission to move forward with their project as proposed. So like the Superior Court in ZBA cases, the board can dismiss the appeal or vacate the order or decision, or in certain instances, grant such order or decision that is wholly or partially vacated, or remand the matter back to the Zoning Board of Adjustment for further proceedings. And like the Superior Court and Planning Board cases, the Housing Appeals Board can reverse or affirm wholly or partly, or it may modify the decision. And again, and this is stated later on in these materials, when the board is persuaded by the balance of probabilities that the decision is unreasonable. And that's the same standard that you face in the Superior Court for a land use board decision. And most of those cases involve, a denial of a subdivision or site plan review, or a ZBA grant of relief under the zoning ordinance. And as always, in any land use case, it's always based upon the certified record, and the burden is upon the person appealing to demonstrate that the board's decision is illegal and unreasonable. And what the board has to decide is there evidence to suggest, based on the balance of probabilities, that the decision that the board made was unreasonable. The Housing Appeals Board has concurrent jurisdiction with the Superior Court. And again, this is that parallel comparison to the Board of Tax and Land Appeals. And again, it was set up, I think, in part to mirror that bifurcated appeal process that is available in aggrievement under real estate taxes. So similar to that process for the BTLA, the Housing Appeals Board has concurrent jurisdiction. So a party aggrieved by decision of the Land Use Board involving housing can appeal either to the Housing Appeals Board or to the Superior Court. But if you elect to appeal to the Housing Appeals Board, that waives the right to appeal to the Superior Court. And again, don't quote me on this because I haven't looked at the statute, but I'm fairly certain that's exactly the case with the Board of Tax and Land Appeals. The Housing Appeals Board can determine whether or not it does not have jurisdiction. And if that's determined by the board, then, so for instance, the question that came up previously, there was an appeal involving just the building of a garage and the setback, and there was no housing unit in the garage, such as a family room over the garage. The board could decide that it doesn't have jurisdiction, and then the aggrieved party could appeal to the Superior Court within 30 days. And generally speaking, if there's one case involved for some reason involving the Superior Court that really should be joined with a similar case, but for the Housing Appeals Board, that certainly could happen. If there's a common nucleus of operative fact, the Superior Court case can be stayed and joined with a related matter being heard in the Housing Appeals Board. I don't know, I suppose it could be possible where some party would say, no, I don't want to have the case go to the Housing Appeals Board. I want to stay in the Superior Court. I can't tell you off the top of my head how that conflict would be resolved, but I suppose that's a possibility. Nevertheless, there is this concept that these cases should be really heard in one jurisdictional venue, and obviously to avoid inconsistent outcomes, which is certainly possible when you have two boards in Superior Court, adjudicatory bodies who could be making decisions which could potentially conflict with each other. So having the case combined with Housing Appeals Board certainly is a sensible approach. So the timing of the appeal, and this is similar to the Superior Court, has to be filed within 30 days of the final decision by the board or committee. And when that appeal is filed, it is the obligation of the appellant, the person appealing, to notify the board or committee that the appeal has been filed. And then the municipal board or committee has to, within 30 days, submit to the Housing Appeals Board a certified record. This is very similar to the process you found in the Superior Court. Certainly with a planning board appeal, the court has to issue a writ of certiorari. And then the land use board persons who are running the paperwork, the back office materials, put together the certified record and send it to the Superior Court, typically with an answer filed by town council. The question has just come in about what is a certified record, which is the same standard that is used in the Superior Court. A certified record is what are all of the documents, emails, plans, anything else that's just reasonably descriptive of what the board did in both receiving the application and acting on the application. So that would include all minutes of board proceedings, all communications by the board to the applicant or abutters, all copies of plans, all copies of definitive reports from engineers or wetland scientists. I think anybody who represents a municipality, the sine qua non, the key factor in being successful, either in front of the Superior Court, and certainly this is true with the Housing Appeals Board, is you put together an extremely detailed certified record. You paginate it, you put chapters, you put indexes, and I don't underestimate the power of highlighting stuff that you think is important. Now, you have to highlight it for all the copies that you're making, but you just want to have it paginated, indexed, whatever you can do to make the review of the certified record descriptive and available to the decider of what you want to prove as a municipality, that the board's decision was founded on sound evidence in the record and on the balance of probabilities the board's. And you don't have to prove, by the way, your decision was reasonable. The burden is on the person appealing to prove your decision was unreasonable. Your job is to point out, and that's why a certified record is critical, having a really well-organized, detailed, chaptered, indexed, paginated certified record. So when it comes time to explain what was the evidence upon which the board made a decision, you can say, well, on page 55 of the certified record, we had this evidence. And by the way, I think it's a good idea as part of a certified record, certainly this was always my practice, is get a certified copy of the applicable regulations. So either get it from the town clerk or someplace else, certified correct copy of your zoning ordinance or subdivision regulations as a separate document. So if there's an issue about whether or not the denial was based upon some element of the zoning ordinance, there is a certified copy of the actual adopted instrument in front of the decider, Superior Court, but in this case, Housing Appeals Board. You can cite the chapter and verse in the certified zoning ordinance to demonstrate that this is to justify the decision by the board to either grant or deny the permission. And then the board, once it received this information, and again, I think it'd be fair to say, and again, what do I mean by certified? Okay, Scott, certified means you have a piece of paper attached to the front of the certified record, which is addressed to the Housing Appeals Board. This is what I always did in the Superior Court. You have a piece of paper that says to address it to the Housing Appeal Board, Gregory Michael, Chair, Housing Appeals Board, Ray, and then insert the name of the case. And then the letter would say, Dear Attorney Michael, attached here to is a complete copy of the records of the town of, insert name of town, with regard to this matter. And that's certified. Now, if you really want to go to the last extent, you could walk over to the town clerk's office and the town clerk could certify it with the town seal saying, and I hereby certify that the person who signed this letter did so under the pains of penalties of perjury. So you could go to that extent. I don't think that's really necessary, but some representation by the person at town hall puts the certified record together that it's a complete compilation of the records that pertain to that particular application that's under appeal. So I'm hoping that addresses Scott's question. I have another question here. Are video or tape recordings part of the certified record? I always fought this issue in the Superior Court. So in a lot of land use board appeal cases that I've handled in the past, and again, remember, this is not that different, just another body that's handling an appeal of a land use board case, where I would make the argument, Your Honor, the definitive evidence of the board's actions contained in the board's minutes, not the recording taken by an applicant who brought in a recording device and then had that recording transcribed. I was never successful with that argument. Most of the time, the judges are more than willing, and I think the Housing Appeals Board would be too, that they would want to have available to them any additional evidence that would be indicative of what the board did. So unless you have a complete transcript of what the board did, your minutes are a summary. It's my experience, judges, and I think the Housing Appeals Board would say, if you have a video of the proceeding before the board or a transcript or a recording, they're probably going to ask for it. I wouldn't presumptively provide it, but if you think there's some element of what explains how the board reached a sound decision, had evidence in the record supporting a sound decision, is included in a tape recording or a video recording, sure, you can certainly provide that. I would just be aware that the board does now have administrative rules, and I would check the rules on how you would do that before you would actually send it in with your certified record. Then when the board receives all this information, I believe the process includes, the applicant filing a complaint, setting forth the basis for their aggrievement, and then the town filing an answer explaining why the board's decision was not illegal or what was not unreasonable, or basically saying that there's evidence in the record that supports the board's decision, because again, you don't have the burden of proving your decision was reasonable. It's the applicant's obligation to the appeals board to show your decision was unreasonable. The board has to hold a hearing within 90 days of receiving the notice of appeal, and then the board has to make a decision within 60 days. And my understanding is the board has been very diligent to make sure it's meeting these deadlines. Does the 30 days start from the date that the ZBA denied a rehearing? So I would say that my understanding, I'm recollecting off the top of my head, because I'm working remotely, so I don't have my zoning and planning book in front of me. I believe it is the case that for ZBA decisions, it's the date of the board's decision, and the date of the board's decision is when they voted on the motion to approve or disapprove the motion for rehearing. So that, I believe, is the starting point to count the time as to whether or not you have the person appeals within a timely fashion. So as I've said, the appeal is based on the certified record. I can't, again, underestimate the power of a neatly organized, detailed, highlighted, chaptered, and paginated and indexed certified record. It is immeasurably important. So it's based upon the certified record. So there's not going to be testimony. There's not going to be people providing evidence. But the board could, in those cases it has decided merit it, the board could decide to have additional evidence. So I don't know whether the board has allowed additional evidence to date. That's why, again, I would again suggest, if it's material, even if it's not material, certainly anytime a zoning board of adjustments making a decision is based on the zoning ordinance. So having the board receive a certified copy of zoning ordinance, really good idea. Same thing for subdivision and site plan review appeals, making sure the board has the relevant certified copy of those regulations, a very good idea. And I think the board would be happy to receive that information so they know that there's definitive evidence of what are the rules that govern what the board did or didn't do in that particular case. But just like, in the Superior Court, the rules of evidence don't really strictly apply. You're just going to be having a oral argument in front of the Housing Appeals Board as to, if you're the applicant, that the board decision was, not founded on sound evidence and was unreasonable. And if you're the municipal attorney or representative, that there's adequate evidence that supports the decision of the board in the record. And the board can't review, reverse, or modify decision unless, again, based on the balance of probabilities on the evidence before it, the decision is unreasonable. So public access to board proceedings and decisions, and I know there are some who have expressed concern about some of the ways in which the board is currently providing access to the information involving pending cases and decisions. At the current time, what the board does, if you go to its website, you will see that it lists pending cases that are up, that have been scheduled for a hearing. Excuse me. So far as I know, at least the last time I checked the website, they're not actually listing decisions issued. But if you send an email to, which I've done a number of times, to the board clerk and say, I've sent this email a number of times myself. I will send a list. I will just copy and paste from the list of pending cases that are listed as that are going to be heard, the hearing list. I'll just copy and paste that into an email and say, dear, clerk, are any of the cases listed in the following hearing list, have there been issued decisions? If so, can you send me a copy? And she'll just send you a copy without any problem. But the board is required to record proceedings, but you are not going to get access to the actual recording until 15 days after the board has made a final decision. And when the board deliberates to make a decision, so I should start off at the top of this particular slide. The appeal hearings themselves are public proceedings, just like they are in the Superior Court. So there's going to be an open hearing where anyone has the right to attend that public hearing. But when the board makes a decision, the deliberative process where they might meet as a board, that's exempt from the public meeting requirements. And then decisions or orders are publicly available after they've been served, signed by a quorum and served on the parties. Discussions and actions by the board involving procedural and administrative, legal, and internal matters are exempt from the meeting and notice requirement of the right to know law. Another question here. They have been asked for additional information to clarify a point or matter and believe I continued a case for that reason in Patrick Gendron versus Pelham. Yeah, it's certainly possible that, and I think from the presentation that Attorney Michael made at our land use board conference this past month in September, I think he mentioned that is often the case. They'll have a scheduling conference with the board where the board, and I think this might be mainly Attorney Michael, might explore whether there's a need or request for additional information. And that's something that can certainly happen and apparently does happen, and maybe did happen in this particular case, Patrick Gendron versus Town of Pelham. And just like any appellate body, in this case, although this is different from the Superior Court, because this is an interim step between final appeal of any land use board case to the Superior Court, to the Supreme Court, excuse me, you don't do not necessarily motions for a hearing in this Superior Court, but most attorneys probably are asking for a motion for reconsideration if they have a basis to do that in Superior Court, if they want to make sure all issues are addressed and press home points that they don't think the court addressed in the final order that was issued in the case. Nevertheless, just like the BTLA, the Housing Appeals Board is an interim appellate body from whom decisions are made using the Administrative Procedures Act, RSH 554. So before any party can appeal to the Supreme Court, the aggrieved party who doesn't like the Housing Appeals Board decision has to first file a motion for a hearing. So similar to what happens in ZBA cases, you don't like the decision by the ZBA or you don't like the decision by the Housing Appeals Board, you have to first file a motion for a hearing, explaining all the reasons why you felt the board's decision was improper or overlooked or misapprehended certain things or requires clarification. And this is really not an opportunity to submit new evidence, but it's to argue why the board misapprehended evidence. And then the board has the ability to reconsider its decision. There could be, I suppose, the opportunity to submit additional evidence, but it's not likely to occur unless it was newly discovered or couldn't have, with reasonable due diligence, been available at the time of the first hearing for the Housing Appeals Board. So again, you've got to set forth all your arguments in the motion for rehearing. The board has to rule on it. And then if you're further aggrieved by the ruling on the motion for rehearing, then and only then can you appeal to the New Hampshire Supreme Court. The rules and the statute make very clear that the Housing Appeals Board is supposed to be flexibly available as a venue for addressing these issues. So it permits, and again, this is similar to the Board of Tax and Land Appeals, non-attorneys to appear and represent parties before the Housing Appeals Board. So that could include professional engineers, architects, land surveyors who can appear and represent a party before the Housing Appeals Board. And the board has adopted rules under RSA Chapter 541-A, and I've given you the URL for access to the adopted rules, which I believe probably became effective about 40 days ago. So they're now available. And anybody who's involved in a Housing Appeals Board case, certainly good idea to go through the rules and make sure you follow the procedures and processes that the board wishes you to follow in appealing to the board on matters involving housing and housing development. So I want to talk about these two decisions, which I think are the most significant that recently came down. We did cover these in a court update in our website. The first of these decisions, which came down probably about 90 days ago, is Shattuck versus Francestown. So it was not a terribly robust or very large housing project. The application was proposing a lot line adjustment to create 4 new building lots. And if you review the decision, I didn't review the certified record. Ostensibly, the planning board denied the plan because it did not conform to the general purposes of the town's subdivision and zoning regulations. I think the key issue in the case was an argument, this was by the person who was appealed, this is the Shaddocks, that there really wasn't any strict nonconformity in the zoning ordinance subdivision regulations. It was these general standards, which are often found in the first or second part of a zoning ordinance or subdivision regulations. And the Housing Appeals Board concluded that the planning board's decision to deny the application was unreasonable or legally deficient. And I think the key issue for the board was that there was nothing clearly identified in the regulations about which the application was deficient. And so the decision of, the planning board decision that no substantial benefit would be granted by approving the plan was not supported in the decision that was rendered by the planning board. And that's the reason why the Housing Appeals Board overturned the decision. So I think what I always like to point out in cases of this type, especially now with the Housing Appeals Board, is what is the practice pointer for the municipal practitioner, whether it's the land use board administrator or board member. I guess the key thing I would say is if you're going to deny an application, a planning board application, due to non-compliance with the zoning ordinance, they really have to be direct, clear zoning nonconformities, and reliance on generalized statements of a zoning ordinance's purposes probably is not a sufficient basis to deny an approval. And I think probably in fairness to applicants, this allows an applicant or whether it's appealing a planning or zoning decision to really determine, what are the things that are wrong with my application and how do I go about fixing the problem? Because if it's very hard to address a vague statement of sentiment or spirit of the ordinance, as opposed to you didn't comply with the wetland setback requirements, or you didn't comply with some other element, specific element of the regulations. And I think the other thing that was apparently of concern to the board is that some planning board members were inserting their subjective personal feelings into the board decision rather than relying upon, compliance with the board's, clearly stated standards that the applicant did not satisfy. So Audrey has a question. Isn't the threshold stated in the handbook that there is not substantial harm to the public benefit? And there is no substantial benefit. I'm not sure I agree, Audrey. I think the standard is, but this is a ZBA standard, not the planning board standard. So the ZBA standard is, and again, if you give me a second here, I'm going to try to bring that up. Since you asked, I will take a quick peek because I don't actually remember this always off the top of my head. That's why I wish I had my book with me. So for a ZBA decision, the question is, the variance will not be contrary to the public interest. So this is important for ZBA members to know. The applicant doesn't have to approve that the proposal is consistent with the public interest. No. The applicant only has to prove it's not contrary to the public interest. So keep that in mind. I don't have to prove my project is beneficial to the public at large. I just have to show for a variance that the application, this particular proposal I have, is not contrary to the public interest. And then I also am required to show that the spirit of the ordinance is observed and substantial justice is done. So I guess I'm not entirely agreeing with the supposition there. And Andre has a supplemental question. The court clarifies should not be read to imply an applicant must meet any burden higher than required by the statute. That's correct. There must be a demonstrated public benefit if the variance were to be granted, but merely show that there will be no harm. That's right, not contrary. So I don't have to prove public benefit if I'm the applicant. I just have to demonstrate it's not contrary to the public interest. So again, I think the key thing for the Shattuck case is the vagueness of the board's reliance upon these general standards in the zoning ordinance didn't allow an applicant to go back and re-engineer the proposal specifically addressing those issues, because how do you address a vague standard as opposed to, yeah, I can deal with a wetland setback by modifying where the buildings will be located. And then the other recent decision I want to mention is the Evans versus Pembroke case. I guess would say perhaps a little bit groundbreaking in terms of how the board applied its jurisdiction, but not an unreasonable reading of the statute, because in this particular instance, the applicant was trying to get an approval from the Pembroke Planning Board to reclassify a road as Class 5 that is currently Class 6 to facilitate a housing development. And the board legitimately could argue that that's a decision affecting housing, therefore, and it was by another board or commission, in this case, the select board, and the board, looking at the evidence, decided, contrary to the decision by the New Hampshire Supreme Court, the board had improperly weighed the impact of the proposed residential project. So if you look at the Green Crow case, what you learn is the Supreme Court said, when a board is acting and deciding whether or not to grant a layout under the layout statute, which is RSA 231:8, which is issues whether there's an occasion to grant the layout of a Class 5 road or a Class 6 road. The issue was whether there's an occasion, but that the issues that come into understanding whether there's a sufficient occasion does not include what will happen once the project is built, but it's the more larger question about, is there a sufficient public benefit based upon the probable need to maintain the whole road in the future, not what will happen once the road is built and there's more homes in the area. And so, that's evident by the board's decision, the Housing Appeals Board decision here, that the board made a decision which was inconsistent with the statute, and the layout statute 231:8 was not designed to effectively conduct land use planning or zoning. That has different purposes for the jurisdiction of the select board in granting layout petitions. So keep in mind, I think the main thing I want to point out here is that the Housing Appeals Board can deal with issues by any board or commission that touches and concern housing and housing development. In this case, I think it's not unreasonable for the board to conclude you don't allow this layout of a Class 5 over a Class 6 road. That's going to effectively stymie this housing development. And I think just generally keep in mind, I think it's true that when the select board is taking up this issue to deal with converting a Class 6 road to Class 5, it's not appropriate to consider the anticipated impact associated with the development that might result from the upgrade of the road. So that brings to an end the materials I have. I think that's it. Yes, the next slides are more information about upcoming events. So I've completed my presentation efficiently, I hope, and without too much stumbling around, 15 minutes early. So I'm happy to, again, answer any additional questions you might have about the Housing Appeals Board based on this presentation. And again, I just would emphasize, I know there's some concern amongst those in the municipal community about access to board decisions. And should the board perhaps be posting its decisions on its website, on a regular basis, or list them or put a folder up there? I frankly, if that's a concern anyone has about how the board is making information available for its website, I would encourage you just to send an email directly to the Housing Appeals Board Chair, Greg Michael, and raise that concern. I think he's demonstrated he's very accessible and willing to answer and address issues of concern you have with the administration of the Housing Appeals Board, and/or send an email, making those suggestions to the Housing Appeals Board clerk. My experience has been, I went over there one day to the Housing Appeals Board and they just pulled all their files out. I went through them all and I was able to get copies without any issues. So I think, would it be nice if the board would also just put up an inventory of its issued decisions? Well, that's just something that's up to the board to decide, but making that suggestion to them is not certainly, it's a reasonable suggestion. But again, I don't think there's any difficulty in getting access to I hear that, I see that George Reagan indicates that they are planning to post all the decisions very soon. So that's good news. So those of you who want to get access to decisions, but again, what I've been doing is just copying and pasting the pending hearing notices and just send an email to the board clerk, and they easily make those decisions available to you by email. So I don't think there's a real issue about, getting access to what the board has been doing or its definitive decisions, which I think are generally available. The other thing I would point out, I did receive an email from the Housing Appeals Board about this presentation. And one of the things I do know is that the Pembroke case is one where the case was remanded back to the Town of Pembroke. The Town of Pembroke issued a new decision about the layout. I don't remember what the decision was, but there's been no appeal that we're aware of from that case or the Shattuck case to the New Hampshire Supreme Court. So far, the decisions all the ones that have been issued are final decisions by the Housing Appeals Board. There's no pending appeal to the Hampshire Supreme Court. So Tim, I don't see us getting any further questions at this stage. So at this stage would probably say, Tim, do you want to go through the upcoming events? And I'd be happy to run the slides for you.
Yes, why don't we do that? And maybe a question or two will percolate in between.
Yes.
Starting tomorrow morning, we've got Steve Buckley and Nate Grays giving us a lesson on the right to know law and governmental records and public meetings, a virtual workshop. Costs $55. If you haven't signed up, we encourage you to do it as soon as possible. The next one, on Tuesday, October 19th, we have Jack Martell from Freedom Energy Logistics, who will discuss with us how New Hampshire municipalities can take advantage of the expanded net metering opportunities. That's House Bill 315 and its impact on municipal users. Next slide, Steve. And specifically for law enforcement officials, we've got a right to know law virtual workshop for law enforcement. That's Wednesday, October 20th. It's also $55. And we've got the Buckley and Grays team who will share their insights and strategies to assist you in handling governmental record matters arising under the right to know law. And
actually,
lastly,
Tim, that's just going to be me because Nate is otherwise engaged. So you're stuck with me for just law enforcement.
Well, thank you for the clarification. And the next slide,
I think that's it, Tim. But we do have another question. Oh, wait a minute. No, but last but not least.
One more slide. Thank you. Our annual conference is November 17th, 18th, and 19th. We are going to be doing a live show at the Doubletree in Manchester on November 17th. And then we'll be doing virtual programming both Thursday and Friday, remote learning. We've got over 40 educational programs. We hope that you will join us either live or virtually. Steve, a question did come in. Do you see it? Want me to
Yes,
read it?
I do. The decisions of the Housing Appeals Board became case law going forward. They are not binding, or they do not, under what we would use as legal jargon, have precedental value. But what they do provide is guidance. So it's the reason why sometimes we will provide to our members a summary of important Superior Court decisions, or important, in this case, Housing Appeals Board decisions, because they provide you guidance of what may happen in a similar case involving your municipality in the future if it is appealed to the Housing Appeals Board, but it is not binding precedental value. But however, I would say if I was in front of the Housing Appeals Board, I'm representing a municipality, and I was aware of a prior decision by the board that seemed to suggest X, I would make that point if I felt that particular legal proposition was the same issue that the board was facing in my case. But it's not binding precedental. It would only be offered as guidance. Only the New Hampshire Supreme Court in our legal system can issue binding common law decisions that boards and commissions are required to follow in the future. So it's guidance, but it isn't necessarily having precedental value.
Excellent.
So,
Steve.
Tim, I think we're done. Do you want to say a few words about this wrapping up?
Yeah, exactly. We will be wrapping this up into a YouTube video link, and with the PowerPoint presentations, be getting that out to everyone who registered for this webinar. We encourage those who were unable to be live with us today that we hope you'll share these materials with them. So thank you for joining us today. Steve, excellent job as always. Appreciate you sharing your expertise with our members. I think that's a wrap.
Thank you everyone for joining us today.